10 minutes. it may, please, Honorable Court, I know talking about it. Please, Mr. Emerson for the statement.
If it pleases you, my Lord TST Petero, I still argue on behalf of
May I please Please, your Lord, I appear with Advocate Imbayo. We appear on the strength of subpoenas directed to our client, Mr. Chimombe. Lord, we register our appearance on the strength of the authority in Net One Cellular and another, this is Econet Wireless and another.
It's just waiting. Case name again?
It's Net One Cellular Private Limited and another. And this is Econet Wireless Private Limited and another. It's SC47 of 18.
What is the ratio?
Yes, you know, the judgment of the Supreme Court settles four things. The first is that a witness subpoenaed by the court has a right to legal representation. That is the first principle. It must not be subject to question. The subpoena is a legal process. Secondly, it settles the position that a subpoena must follow 3 or 4 things for it to be valid. The third thing it settles, my Lord,
The subpoena must satisfy
at least 4 requirements for it to be valid. But I will deal with those as and when the question of the subpoena to our witness, to our client, arises. It also settles the point, my Lord, that the party which issues a subpoena or requires the presence of witness must meet the costs of that witness, including the cost of counsel. And for those arguments, my Lord, to be made at the relevant time, when our involvement is required, we must register our presence on the record, and the court must recognize our presence. It is for those reasons, my Lord, we appear before you. My Lord, the most important point which I had forgotten, and I'm indebted to my learned friend, is that a witness is permitted at law to challenge a subpoena on the day he is called to testify. So we've been called by a subpoena to appear, and we place it on record and on notice to those who subpoenaed us that we intend to challenge the subpoena. And his lordship is within his rights to hear the challenge and to resolve it. My Lord, on those submissions, let the record reflect and recognize our presence. Those would be my submissions.
State.
My Lord, the witness was called at the instance of the accused persons.
So you have
No input.
Mr. Ashiti, it is your position that
law and procedure is enunciated in the matter that you've cited applies to criminal cases?
It does. It applies to all subpoenas. And in fact, it derives its ratio from the common law. And my lord, curiously, the ones who brought us to court, they have not taken us into confidence as to why they want us here. So we are at large, my lord, to challenge the subpoena.
Very well, thank you. Thank you for the clarification.
Amen.
Mr. Maduka.
Thank my lord. For the accused persons, we first have no issues with the fact that a witness who is called to testify may have legal representation. So we are not in any way challenging the right of the witness to have legal representation. But when we listen to Advocate Ashiti, it would appear that he would want to challenge the subpoena. In other words, he's saying that the witness that they are representing ought not or was not validly subpoenaed. We respectively submit that that issue would then have to be determined. We are not aware of the basis upon which they are indicating that. We made indications at the last sitting, and the list of the witnesses that the accused persons wanted subpoenaed. And those witnesses, with respect, we are indebted to the state. The registrar, the witnesses, we understand most of them are present. Now, for us to then start proceeding, we would need to deal with that issue if the court so pleases. We have not heard the basis. It is also up to the direction of the court whether that challenge would come at a time when that witness would be called. But that could be quite disruptive to the proceedings. We need to know which witnesses have been subpoenaed and who would be in the line to give evidence.
I think he has been specific that he is here at the instance of Mr. Jivai.
Yes, indeed, my lord. We are saying it appears that he is saying this client is not properly subpoenaed, unless I have misunderstood.
No, I understood him to say that the accused persons have not advised this client why he's being subpoenaed and why he's required at court.
We were not aware
unless you want Mr. Ashiti to proceed first. If you are not clear, let Mr. Ashiti clarify. Mr. Ashiti, you stated.
My lord, there are witnesses who are in attendance whose evidence from my learned colleagues is that their evidence is they may not be interested in such evidence. There is the I.O. Chapkanya, there is also Ms. Shonai. If they have made their decision on those two witnesses, they can always say so that the two witnesses may be excused before getting to contentious issues.
Mr. Maduko?
Yes, my lord, I would defer to my learned friend here, Mr. Jetero, on that point.
You said the I.O. and Ms. Shonai?
Yes.
Who is the I.O.?
It's Henry Chapkanya and Mr. Shonai.
Yes, Mr. Jetero?
Yes, thank you very much, my lord. We had occasion at the direction of the court to speak with our colleagues, and we had come to agree on certain facts in respect of the said two witnesses. And having agreed on those facts, we were of the view then that we may dispense with them taking viva voce evidence, and we may proceed by filing a statement of the agreed facts in respect of those two witnesses. My Lord, in summary, the agreed facts were as follows.
Wait.
No. All right. My Lord,
why don't you prepare the statement of agreed facts, which will then be read into the record?
Indeed, my Lord, that's what I wanted to now suggest.
State, is that correct?
The summary of what that the defense said they need to adduce from the two, as summarized to the state verbally. The state was not opposed to it. Yes.
So the state was not opposed to the facts that the defense would like to place on record.
Yes.
So there will certainly be a statement of agreed facts with respect to the evidence of those two witnesses.
Matter of fact, there is no statement of agreed facts even in relation to the previous issues which were agreed upon. I think it has to be eventually consolidated into one statement rather than piecemeal.
Yes.
Yes.
So I'll just place on record that the state, there has been liaison between the state and the accused persons with respect to the evidence of Henry Chapkanya and Ms. Shonai. And there's convergence on the facts that will be placed on record by way of the statement of agreed facts, or to be included in the statement of agreed facts.
Indebted, my Lord.
Indebted, my Lord.
Yes, in that event, then, can you call the witnesses? Ms. Shonai and Mr. Chapkanya, the accused persons have decided to dispense with your viva voce evidence. I'm sure you have been following, because there has been some agreement reached between the state and the accused persons. You will therefore not be required to give evidence in the excused.
My Lord, while on that basis of what has just transpired, we would want to seek a standing down of the matter to enable us to have a discussion with Advocate Shashit and his assistant. We think that it would be in the interest of our progress if we were to do that. I mean, the way we made progress with the state in respect of those two witnesses is something that we think can be achieved in respect of their client. It might be useful if the court could give us perhaps a briefer standing down, perhaps another 30 minutes, 10, 15. We didn't want a situation which was already beginning to arise, where I think my learned friend was very much prepared to argue and argue the way he started. He was really ready for a fight. We are not in that mood. We really want progress in the matter. And we are very much convinced that if we sit around with our colleagues, we then indicate to them what it is that we want from their client, which is all in fairness, that is what we ought to do. It may be late, but I think it's necessary. We didn't know that the legal representation. All along, it was Mr. Mabaud who appeared to be representing everyone. So that's our request, my Lord, a short adjournment so that we can discuss this matter.
State.
The state is not opposed to the 10-minute adjournment being proposed. Say 15. Yeah, 15-minute adjournment. If that would result in some progress.
Mr. Ashiti.
Lord, we are happy. At least now someone wants to talk to us. We've been waiting. No one has been talking to us. We are happy with the adjournment, but we must make the point that it is a concession to our presence. Our presence alone has yielded the concession. It will come with costs, and we will pay for those costs.
So how many goats? You're praying for how many goats? Goats? Oh, wait. What am I for your costs?
I'm sure those of you who have read Gulliver's Travels will know what is going through my head. We have really packed the business and we are now dealing with other issues. I encourage, once again, the bar to resolve all issues so that we can go back to real business. The whole purpose of our convening this court. Having said that, we resume at 12 o'clock.
As you please, my Lord.
The court will adjourn.
Merry Christmas. Yes, my lord, I remain on my feet because my process, which caused the adjournment, has been concluded. And my lord, if it may please you to issue an order in terms of the agreement of the parties in the following terms.
Yes.
One, that the subpoena issued against Mr. Wikino Chivayo in the matter be and is hereby set aside.
Issued with respect
For Mr. Wikino Chivayo in this matter be and is hereby set aside.
Yes.
And two, the first and second accused shall meet the costs associated with the attendance of Mr. Chivayo and his counsel at today's hearing.
Shall meet the costs associated
With the attendance of Mr. Chivayo and his counsel or legal practitioners at today's hearing.
You confirm that, Mr. Madu?
Yes, I confirm that that order will be issued by consent.
Very well. By consent, it is ordered as follows. The subpoena issued with respect to Mr. Wikino Chivayo in this matter be and is hereby set aside. 2. The first and second accused persons shall meet the costs associated with the attendance of Mr. Chivayo and his counsel at today's hearing.
As you please, my lord. But with that, might I and that within by one be excused.
Very well.
And Mr. Chivayo as well.
It follows.
Yes, I wish to advise the court that the accused persons will not also be pursuing the calling of the other witness who remain outstanding once we have dealt with the first two that were excused on the basis of what will be contained in a statement of agreed facts, and then what the court has also issued in order by consent in respect of Mr. Chivayo. We remain with Mr. Michael Reza. The accused persons are no longer pursuing, calling him to give evidence on the basis that in the statement of agreed facts, my learned friend would confirm, Mr. Mabaudi, that we will include some video in which that witness was appearing without need to call the witness.
So you're producing a video?
There would be a video. We will produce a video with the consent of the parties in respect of what we would have wanted that witness to say.
A video would be evidence, isn't it? But you should be able to distill the fact that you want to place on record from that video and make it part of the statement of agreed facts.
Indeed, my lord, I can just clear that issue. I think we would withdraw that point. All we need to say is we will produce a statement of agreed facts as per the previous indications which the state consented to. We are not calling Mr. Reza. If there is going to be anything in the relating to him, it would appear in the statement of agreed facts. But without the agreement of the state, we will not include that. We have to make that point.
Yes, very well. Anything outstanding with regards to evidence to be laid or the other facts relating to the other constitutional issues that have not been argued?
There will be no other evidence to be laid. What will remain will be, I think, to motivate once the state has responded on the legal arguments.
Yes. You mean the state to respond now to the legal?
I'm saying if there is going
once
to be,
the statement of agreed facts is before the court.
once we have the statement of agreed facts, then the court will direct us. There will be submissions. I think the state still had to respond to our side. We had motivated our legal arguments. Then we made to motivate.
But have you, has Mr. Mugias motivated, because he needed to lay a basis first, and he was then going to make submissions regarding the issue for referral?
Indeed.
He hasn't done so yet.
Yes, that will be done after we have the statement of agreed facts. Then Mr. Mugia would then give his last portion.
Close his submissions.
Before the state responds.
So when can we have the statement of agreed facts?
I'm not sure what we need to liaise with the state.
My Lord, it is their case. The state tried to jog their memory by reminding them that there is need for a statement of agreed facts on issues that had already been agreed on, which it hasn't been done. We were expecting that we should have met before today, but it looks like there is no joy. It looks like people, they are meeting when they get to the bar. That is where serious consideration is being made to issues before the court. But otherwise, it is proving they are the ones who are supposed to chase people around, because it is their case. In terms of Section Rule 108, which mandates that there be a statement of agreed facts, they are supposed to be pursuing it themselves, which they are not doing. So the issue cannot be left to the state, because it's not a matter for the state. Yes.
Mr. Maduku, the suggestion is that the defense is only getting down to serious business when you meet at court. You are not really giving priority to this matter, or to be prepared to make adequate preparations. And I tend to agree with the state. I have directed twice that there should be at the very least a summary of the evidence to be laid. And obviously, if there was an indication that there would be agreement, and that that would obviate the need to call that evidence, you would have come prepared with a statement of agreed facts anyway. And I think I advised that counsel that you are required to speak to your witnesses and make sure that you know whether they've got the evidence that you require, and also that all those directives have not been complied with. It obviously it is not right that directions given by the court should be, as it were, not be followed by counsel, and more so in a criminal case where accused persons are in custody. We need to expedite. We started on the 1st of October, and we are approaching mid-November. We haven't gone into the merits of this matter, if we have to. Or at the very least, you don't have an outcome to the intended request for referral. We cannot take 1.5 months to motivate an application for referral. It reflects badly on our judicial system. I don't know what you intend to do to remedy that, but I really expect you to take these proceedings more seriously.
My Lord, with respect, we accept that we have not been doing it to the best in terms of administratively and organizing ourselves. So we take responsibility and apologize to the court for that. The court will also have noticed that we have since dispensed with first accused, second accused, at least for today's hearing. We are trying to reorganize ourselves in that regard. So I can assure the court that all the directives going forward will be respected in full and implemented. I'm not saying we've not been respecting them. It has been because of our schedules during term time. It has been very difficult to bring the work of 4 lawyers together, but we are now going to deal with that aspect. So we apologize for that.
In other words, you want to synchronize the approach so that perhaps we have one lead counsel for both accused persons.
Indeed. Yes. And in fact, we have de facto been doing that, and that's what we would be doing.
Formalize.
So yes.
Very well, thank you.
So in this case, we would need about 2 days to finish that. It's only because we have the other commitments that keep coming, but if we get 2 days, we should be able to finalize our statement of agreement.
I'm not sure that you get 2 free days. You've already said we are approaching the end of the term. We really struggled to get this date.
Yes.
And we put aside other business that we ought to do. What it means now, of course, apart from chamber work, as soon as we postpone this matter, in terms of court business, I'll be idle. It's fine for me, because then I have to attend, but that is not what we want. We want to, when we set aside a day for court business, then we ought to make good use of that time. But so anyway...
would that mean we could have a longer postponement? We can have a longer postponement?
No, please don't consider that.
All right, that's fine.
But should it really be difficult to come up with a statement of agreed facts between now? Okay, let me hear from the state first. Mr. Matuku, let me hear from the state. There are indications that from the accused persons that they may require to attend to certain things, synchronize their approach to this matter, and perhaps have one lead counsel. And they also would want to finalize the issue of the statement of agreed facts, and that they would require a postponement for that purpose, not less than 2 days from today.
I know this matter had been set for the whole day. If we are to adjourn now, maybe we can meet at our offices at the NPA boardroom. Then we can come up with an agreed, with a statement of agreed facts in the afternoon.
Then we can proceed on some other days.
Then, yes. So in respect of a statement of agreed facts, I think all of them, they set aside the day for this matter. So we can as well utilize the afternoon for that purpose before there's a problem of them getting together. So the issue will be resolved this afternoon.
Yes.
Yes, we can work with that. That in the course of today we liaise with the state to finalize the statement of agreed facts.
Yes, I think we can do that, since we can take advantage of that, since you have several other commitments separately. So maybe let us use this date for the purposes of. In which case, then, do we have to reconvene, or I simply need to direct the parties to come up with a statement of agreed facts and upload the same?
Indeed.
So, on which date shall we proceed? Yeah, Registrar. We can proceed on Friday. Today is the 11th. Friday shall be the 14th, is it? 15th.
It's just, as the court is writing, I think we can proceed on the 15th. Yes. I wanted also to put on record that as part of that reorganization on our part, we might need to, you might have situations where we will not need to be all of us there, the four of us, if one is in a commitment, so that we make progress. So we will be able to make provision for that. The court will excuse whoever will not be there. One of us will inform the court, whoever will be leading the team on the day.
Or in other words, you are saying all of you will be lead counsel, but it depends. You know, in the event that one of you is not available, the other can. I don't think it's a neat way of proceeding with the trial. We all need to have knowledge of what is happening at the proceedings, the evidence that is being laid. Because if evidence is laid in the absence of counsel, that may create problems. I think if you decide that it's my suggestion. As you had indicated, that you would have one lead counsel, and that the legal practitioner that you then decide will be the lead counsel has to be available at all times. The others who are supporting him, it's him obviously, may, if they have other commitments, absent themselves.
My Lord, I will hear you. The problem we're facing is that I'm not available myself on the date I'm traveling to the UK. Okay. And I didn't want that to then stand in the way of the trial. Yeah. But we had made arrangements that during my absence, we should be able to make progress, because it is Mr. Mkia who is going to be, once I've participated in the statement of agreed facts, and then we would have discussed the submissions made by Mr. Mkia, I'm reasonably confident that the next hearing can proceed.
You can proceed. Yeah. Very well. So, in other words, do I understand that to mean that Mr. Mkia will also be the lead counsel with respect to the first accused person, or both attorneys? Let us try and make that distinction for the purpose of these proceedings. I know that the lawyers who have been appearing on behalf of the accused persons are Mrs. Jetero and Mr. Mkia, and you came in very late, perhaps as to assist as advocates. So they would be the lead counsels with your assistance. So they have to be there. In the event that you are unavailable and you think that it is safe, although ordinarily it is preferable in trials, because you then reappear and start arguing at cross purposes with the record. But it's a very unusual situation. But if that is what you want, you will expect that before you raise any issue, you will make reference to the counsels who were present when evidence was being laid. So I do not mind. Maybe as advocates, they are just assisting here and there, and Mrs. Chetero and Mugia, I will not be able to excuse them. They will have to attend, unless they decide that only one of them will represent both accused persons. Let's hear from, or you can confer and advise me.
Yeah, we may need to confer on that.
my lord, maybe I could clarify on that and assist the court, my lord. Yes, indeed, for this particular matter, my lord, it's a joint application that both accused persons are filing. And for this particular matter, we had agreed that each person was going to deal with a particular field. So the only outstanding field that's there is the field that Mr. Mugia is dealing with. And I am counsel for the first accused person. In everything else, I'll be appearing for the first accused person. But I wanted to seek the indulgence of the court for particular purpose of the 15th. I had another matter between the Ministry of Lands and Dr. Chimombe that I was supposed to attend to. So I didn't want to double book myself. So I thought it would be prudent for me to excuse myself so that there is progress. I may join the proceedings later on because it is a civil matter. So in respect of that, Mr. Mugia can appear and he will represent both accused persons for purposes of motivating the points that are left in this application for constitutional referral.
And you undertake to familiarize yourself with what will have transpired on the day in question.
Indeed,
because it is important that you be aware and familiarize yourself with the proceedings, as I said, so that in the event that so that you don't find yourself making submissions that are inconsistent with what is on record.
Indeed, my lord.
But I haven't really ruled on that as yet. I need to hear from the state. It's a very unusual situation. Ordinarily, when counsel is involved in the trial, they must attend all sittings.
Indeed,
it's very unusual. Because what it means is that your client, who is the first accused person, will be appearing without legal representation on the particular day, which to some extent infringes upon his right to legal representation. We might actually be unwittingly agreeing to infringe upon his rights.
Indeed, my lord.
Let us be careful.
I do. Maybe with that in mind, my lord, might I suggest that maybe we start later on the 15th or on another day? I expect that the
later on the 15th, like what time?
Maybe 2:15.
It appears to me from the diary that is the only day remaining where I'm free to be in court all day. Where is that matter?
It's here the High Court before Justice Manyangadze.
Would it please you if I speak to the judge, and so that he may allow you to attend to these proceedings? There are, of course, considerations that we always make in a situation like that. What I could do is to assist by way of conferring to the judge. I cannot really tell you beforehand what the outcome will be, but I'm confident that it's possible that he might understand and agree that the other matter before him be postponed. Is it a civil matter? Is it criminal?
It is a civil matter. It's an agent court application. The parties are about to find each other. They may find each other.
I hope they do today.
And then ironically, Mr. Shit is appearing on the other side, and I shall also relate to him that.
Okay. Well, lawyers don't take matters personally. It's a duty to the law. But anyway, this is a criminal case, and the accused persons are in custody. It is important that we make progress, in the matter. That is one serious consideration, which I'm going to put to my colleague, my brother rather, and there are other considerations which we take into account as the judiciary, which I may also put to him, and I'll be able to report through my assistant here what the outcome of the discussions will be. But I hope that you will be able to utilize the whole day, particularly if there are proceedings here at the High Court. We should be able to organize ourselves as the High Court to make sure that we, at least one matter is dealt with if we're in a situation like this. So provisionally, let us just agree. Well, I haven't did the state. The state, the 15th.
The state will be in attendance.
Very well. So provisionally, in view of that, we will then defer or postpone this trial to the 15th with the hope that we'll be able to start at 10 o'clock. And I've already indicated that I'll liaise with my brother so that we are able to start at 10 o'clock. But meanwhile, let me dispose of this matter by way of a court order.
Noted, my lord.
What rule is it that directs that there should be a statement of good faith? If you know of it, so
108, my lord.
108.
Yes.
I propose to issue an order in the following terms: that this matter be postponed to the 15th of November 2024 for continuation. 2, that in the meantime the parties are directed to meet today and prepare a statement of agreed facts in compliance with Rule 108 of the High Court Rules. 3, that the statement, that barring systemic delays, the statement of agreed facts shall be uploaded by the end of this day. Any issues with that state?
None.
Any issues with that?
No issues.
It is so ordered. Any other business, Registrar?
No further business.
The court will rise.
They will